Hello friends, welcome back to my channel. This is your host Pawan here, and today we embark on a riveting exploration into the recent Supreme Court verdict on the Adani-Hindenburg case. This decision holds profound implications for the financial landscape, and we are here to dissect its intricacies. Stay with us as we unravel the layers of this legal saga on Wealth Wisdom Hub. So let's get started. First, let's see the origin of the Adani case. On January 24th, 2023, US-based short seller Hindenburg Research leveled allegations against Adani Group. The main allegations were about cooking books of accounts, over-invoicing of the import cost, and round-tripping of money to push up its own share prices. As a result, share prices tumbled and Mr. Adani lost $60 billion of net worth. The Adani Group shares also, they lost almost $150 billion as a whole. Subsequently, many PILs were filed seeking probe into the allegations into the Supreme Court of India. Now, what these PILs demanding for? The main issues and remedies sought by the PILs were to look into the impact of fall in share prices on investors and probe into the allegations leveled by Hindenburg Research that the group violated minimum shareholding norms. If you don't know what is minimum shareholding norms, you can go to the link on the I button above, and I will also put the link in the description, and that will be helpful for you. So, the third demand was to look into the role of LIC and SBI in funding Adani companies. That these people are using their the public deposit in these companies in SBI LICs to fund their own acquisition. And this has been leveled by these allegations has been leveled at various levels, including politicians, and even these PILs were talking about them. The fourth demand was to file an FIR against Hindenburg Research for taking advantage of short selling by releasing this report. So, what was SC's initial response? Since SEBI was already probing the allegations, the Supreme Court directed to SEBI to continue the probe. And they also asked them to prove the failure to disclose related party transactions and stock price manipulations allegations on Adani companies. They also formed a 6-member committee under retired Supreme Court Judge Mr. A.M. Sapre to investigate any regulatory failure in this Adani case. They also asked the committee to suggest measures to strengthen investor protection and awareness. The A.M. Sapre committee subsequently they gave clean chit to SEBI on any regulatory failure and regulatory incompetence. So, what the Supreme Court's current order says and what it is talked about. So, the Supreme Court has said that they are more or less satisfied with the SEBI's probe, and there will be no transfer of cases from SEBI to any SIT or CBI. The cases should be transferred in extraordinary circumstances only. Investigation completed in 20 out of 22 cases, so the Supreme Court was largely satisfied with the pace of the probe. Supreme Court also directed SEBI to wrap up the investigation of the remaining 2 cases in next 3 months. The Supreme Court also found no ground to revoke FPI and LODR amendments done recently. If you don't know what is FPI, it is Foreign Portfolio Investments, and LODR is Listing Obligation and Disclosure Requirements. SEBI had amended these requirements recently, and people were alleging that this has been done to benefit Adani, but SEBI had found them to be in order. Government and SEBI to look into infractions of law by Hindenburg on short selling. So they have also asked government and SEBI to look into any violations of law done by Hindenburg Research for their own profit booking by releasing this report. And they have also, Supreme Court also rejected the OCCRP, that is Organized Crime and Corruption Reporting Project report on Adani, which was released recently, and that also wiped out almost 35,000 crores of net worth from the Adani company. And they said though they can act as inputs for SEBI investigation and other regulatory bodies, but they cannot be based for doubting SEBI investigation, and these reports cannot be the basis of transferring cases to any third party or any SIT. Now, what will be the consequences of the verdict? This verdict can be seen as kind of a final verdict. So, Mr. Adani welcomed the judgment. He tweeted with Satyame Vijayate. Now, SEBI will be the sole regulator examining allegations of rule violations by Adani Group. So, there will be no other party or investigating agencies involved. And this has also enhanced the credibility of SEBI in the eyes of the investors and other regulatory bodies. SEBI, though they have limited jurisdiction over Hindenburg, so it is difficult for them to take any action or enforce any judgment on them. Investigations are almost complete, so Adanis can have a sigh of relief. So I will say this judgment is a kind of a final judgment only, and that's why it has settled all the apprehensions, all the doubts casted on SEBI about their investigation. So I think this matter is almost settled, and Mr. Adani can have a sigh of relief. If nothing, any other new false allegations comes up, he can just relax now. Also, he can also relax because the companies, they have almost recovered all the losses made by Hindenburg Research, and he is again India's second richest man. So, friends, I hope this video is helpful to you. As we wrap up today's deep dive into the Adani-Hindenburg case, remember, knowledge is your greatest asset in the world of wealth. The Supreme Court verdict is more than just legal jargon. It is a turning point for investors and business alike. If you found this information valuable, make sure to show your support by giving us a thumbs up, hitting the subscribe button, and ringing the notification bell. Your likes and subscription fuel our journey to bring you more insights. Stay informed, stay strategic, and I'll catch you in the next episode of Wealth Wisdom Hub. Until then, keep growing, keep thriving. May your health journey be filled with wisdom. This is Pawan signing off. Thank you so much.